The South African Bar Association hosts a speaker on a bi-weekly basis to deal with a legal topic that is intended to assist legal practitioners and any other interested parties, both locally and internationally, with training and development, which perfectly ties in with our core values as an organization. Before we can begin, my name is Moekoa, and I thought I should just introduce myself quickly and just run down the housekeeping for the day. An appeal to all participants to please ensure that your video is switched off and that your microphone is muted throughout the presentation. Should you have a question, please note that we will facilitate a Q&A segment at the end of the discussion where you are able to ask your questions and get feedback on that. Please also ensure that your questions are strictly aligned to today's topic and not outside. I would like to hand over to my colleague, Advocate Reinfeldt, to facilitate the introduction of this. Thank you.
Good afternoon, colleagues. It is really an honor to be with you, and thank you so much for joining us. Today, the presentation will be given by two officials from the South African National Defence Force. First of all, we'll be having Major Nthabiseng Raphuti. Major Nthabiseng Rebecca Raphuti is an admitted attorney of the High Court of South Africa with 14 years legal experience. She is a fraud and corruption prosecutor and a senior officer at the South African National Defence Force. She has gained her legal experience in various legal fields and organizations, which include, but not limited to, Legal Aid South Africa, a prosecutor at the National Prosecuting Authority, a conciliator at the National Consumer Conciliation, and a mediator at LIPCO Law for All. She is also a deputy chairperson of South African Women's Lawyers Association in the Northwest Province and a chairperson of the Gender-Based Violence Committee. Welcome, Major Raphuti. Then we will be having Major Andries Moekoa. Andries Advocate Andries Moekoa is based in Pretoria, South Africa. He currently holds the rank of a major, a senior officer within the South African National Defence Force. He works as a military law practitioner for the Defence Legal Services Division, which he has performed since 2013. He is also a coordinator for the Department of Defence Pupillage Program. He also holds 2 law degrees, namely a LLB degree and a LLM in Public International Law. He is currently a candidate LLD student at UNISA, and he is an admitted advocate of the High Court of the Republic of South Africa. He specializes in international human rights law, law of armed conflict, criminal law, and military law. Thank you so much for this presentation. Thank you.
Thank you.
Thank you very much, Advocate. I will just move to quickly share my screen. I hope the screen is visible on your side.
It's all clear, thank you.
Thank you. Advocate, I think it's very important that I, on behalf of the Adjutant General, thank the leadership of South African Bar Association for the opportunity for us to come and share a brief overview of who we are as military law practitioners, defense legal services, and what we actually do on a day-to-day basis. Obviously, I'm going to be carrying this weight together with my colleague, Major Raphuti. What we have decided to do is that one will present, and then at the end of the day, questions will be tackled by either of us at any time as and when they do arise. I will start then with the scope points, which I will not dwell much in because I'm worried about time and the magnitude of the slides that we need to get through. So I'll move straight to the introduction. I hope it reflects properly that side.
All in
Advocate?
order. All in order.
Okay.
Thank you.
Thank you very much. Now, one thing that's very important is that military law remains very much largely unknown, and I dare say the exclusive reserve of men and women in uniform. And it is also not widely taught at institutions of higher learning, universities. Never mind law schools or with pupillage program, it is not really taught there. But what is also interesting is that the jurisprudence of military courts is equally largely inaccessible, in a sense that legal practitioners that appear in military courts are not able to have access or adequate access to the jurisprudence of the military courts. But there is an interesting move currently by the department, as there is a project ongoing where all the cases of the Court of Military Appeals are now being made available on SAFLI. And I think I challenge all the advocates to go and look at SAFLI and search military or Court of Military Appeals cases. But also one other challenge is that very little or no textbooks in the Republic deal with military law. So with this background in mind, one would understand that it's very difficult to understand what military law is. And I move to just then deal with a definition of what military law is. Now, obviously, it is a body of law, a system of rules that regulates the armed forces of a country, and it is a system that guides the conduct of military personnel. Now, essentially, it is a law that regulates the conduct of soldiers in times of peace, but also in times of armed conflict. It provides for the rights as well as the duties of members who are subject to the military discipline code. Now, one thing that's very complex is placing military law within a specific discipline of law. It's very difficult, primarily because it is influenced by various branches of the law. And also the understanding of military law may differ from country to country because different armed forces treat their soldiers differently. But also, Advocate, I must say that different countries sign different international instruments that affect the conduct of soldiers in times of armed conflict. Now, with us having then understood a little bit of the definition of military law, I think then it's important for us to look at the sources of military law. Where do I go as an advocate if I want to read up on this military law? Now, first and foremost, I think the Constitution is the first place where you can go to read a little bit about the military or the defense force. Now, there are a number of legislations that affect our conduct and our business. The Defense Act of 2002, together with the Defense Amendment Act of 2020 and 2010, we've got for military courts and military law practitioners, the important piece of legislation is the MDSMA, the Military Discipline Supplementary Measures Act. It's a 1999 piece of legislation. Together with the rules, it's important to understand that we've got our own rules in the military courts. Then we also have the surviving provisions of the 1957 Defense Act, together with the Military Discipline Code of 1957. Now, there's one interesting piece of legislation, very old, the Defense Endowment Property and Account Act of 1922 and 1929, which remains to this day in place, Advocate. But also now in 2012, we had the Military Ombud Act. Now, the Military Ombud Act is very interesting. And then I must emphasize, Advocate, that this is not a closed list of all legislation that have a bearing on the work of the defense force. Domestically, in fact, many other legislations affect our business. But also internationally, the various instruments that the country signs or rectifies has a bearing on the conduct of soldiers day to day. So those are just some of the few places where one can go to learn a little bit about the Defence Force. But now, in order for us, advocates, I move now closer to Defence Legal Services with its courts and military practitioners, it would be amiss of me to talk about them without talking about the mandate of the South African National Defence Force. Now, the Constitution is very clear about this mandate. It says that the primary object of the South African National Defence Force is to do three things. The first one is to defend and protect the Republic, its territorial integrity, and its people. But it did not end there. It continued to say, in accordance with the Constitution and the principles of international law regulating the use of force. Now, in simple English, advocate, this simply states that the Defence Force exists to fight and to win wars. Now, my role as a military law practitioner, or our role, is just basically to ensure that when the Defence Force fights, it's able to kill and destroy within the prescripts of what the Constitution allows and what international law allows. Now, advocate, if we're going to entrust the SANDF with all these weapon systems at their disposal, one thing that the Constitution therefore demands is that this Defence Force must be structured and managed as a disciplined military force. So,
apologies, Council. Sorry,
yes,
Council. I just want to verify, are you presenting according to your presentation? Because if that is the case, we're still on that one slide of pillars of legal support. It hasn't moved.
Oh, no. Then it means we are supposed to be here on slide 11. Are you on slide 11?
We're on, okay, go back. We're on 9 now. 11, there we go. There we go.
Are you on 11 now?
Now 11 appears on our screen.
Oh, apologies. It seems I had opened a different PowerPoint.
Oh,
apologies.
no worries. Okay, thank you so much.
Thank you very much, Councillor. Now, importantly, for those that might not know, the South African National Defence Force is composed of various services, which are, for example, the South African Army. We are Army officers. There's also the South African Air Force, the South African Navy, and the South African Military Health Services. Now, in each of these services, there are military law practitioners that are embedded to provide guidance there, legal support to each of these services. Now, let's look at Defence Legal Services and what it is. Now, in order to support this mandate of the SANDF, Defence Legal Services Division, which is a service within the SANDF, was established to provide legal support to the Department of Defense, but on military issues across the full spectrum of conflict and across all levels of war. That means from the national strategic level down to tactical level, because war is waged at country level, military level, operational level, as well as tactical level. So the Adjutant General is charged with providing legal support to the Minister of Defense or the Ministry of Defense on military issues, the Secretary of Defense, the Secretariat on military issues, together with the Chief of the South African National Defence Force, or rather the entire Defence Force. I hope it makes sense so far. Now let's look at the structure. Now at the top of Defence Legal Services, you're going to find the Adjutant General. Advocate, this is the only Adjutant General in the entire Republic of South Africa who is the head of legal services. Now, under him, there are various directorates or authorities that exist. The first one, in no particular order, is the Directorate Operations Legal Support, DOPS-LS. Now, this is a directorate that provides operational legal support. The guys at the front lines that are fighting, they provide legal support there. Then there is what we call the Military Prosecuting Authority. Now, we would know the Constitution speaks about a single prosecuting authority for the Republic, but now I am talking about a military prosecuting authority. We will get into a discussion later on issues around this topic. Then we also have what we call Military Legal Defense Council Authority. It's basically the same structure as Legal Aid South Africa, providing legal representation at state expense. Then we've got the Military Judicial Authority. It is nothing else other than the military judiciary, if I might say so. And then we've got the Military Review Authority. All cases of the military often go through automatic review. So this is one authority that assists in that regard. Then we've got a Directorate Litigation and Advice. These are the people that are the go-between between the state attorney as well as the Department on Litigation Issues, but also that provide legal advice to the Department of Defense. And then lastly, we've got, for example, Directorate Legal Services Support. These are the people that exist to support the military law practitioners or the various court functionaries. So court orderlies, you find them here. Court interpreters, you find them here. Now I want to move to what we call legal satellite offices, because I've told you now about Defense Legal Services that is composed of directorates and various authorities, but also across each of the provinces, there are what we call legal satellite offices that essentially this is where our courts are across the country. For example, in Bloemfontein, it's the seat of Lexato Bloemfontein that is responsible for the whole of the Free State, as well as the whole of the Northern Cape. Then we've got Lexato Cape Town, which is responsible for the whole of the Western Cape, together with parts of the Eastern Cape. We've got Lexato Polokwane, which is responsible for the whole of Limpopo, together with the Mpumalanga province. Then we've got Lexato Durban, which is responsible for the whole of KZN, as well as parts of the Eastern Cape. And then in Gauteng, we've got Lexato Thabatshwane, and it also supports Northwest province. And then we've got now Operation Support Lexato. This is the Lexato that provides admin of justice in all operations, whether it's in Mozambique, where the forces are, or in DRC and any other place where the armed forces are. Those cases are dealt with by this particular Lexato. Now, it's important then to deal with the pillars of legal support. For our purposes, there are 4 pillars of legal support. One, it deals with force preparation, operational law support, which is force employment legal support, support when we are fighting the war. And then administration of military justice is just simply the court system. And then we've got the legal advice and litigation support to the DOD. Now, in short, I'm going to indicate in simple terms the role of military law practitioners in each of these pillars. The first pillar that we'll look at is the operational legal support pillar. There, the military law practitioner working in that environment would concern himself with drafting employment papers and presidential minutes for the president prior to the president employing the South African National Defence Force, memorandums of understanding, the status of mission agreements, status of forces agreements, rules of engagements. They are involved in targeting considerations and contract vetting, but also they are involved in mission readiness, preparing soldiers from a legal point of view prior to them going into an armed conflict. Again, also, we look at operations legal support in the planning, execution, and the post-review exercise. Here, that's where majority of the time we do monitoring. And lastly, legal support plans and letters of assist. Now, the second pillar that we have is the litigation and advice. Here we deal with contracts and dysfunction, legal support, policy and general legal support are dealt with here. We've got legislative drafting, But also here we've got memorandums of understanding legal support. This is now at an interdepartmental level. In the operations legal support is MOUs at an international level, country to country. Here is now interdepartmental level. And then also we've got obviously human resource legal support. And then now what councils would want to know, because this is where briefs come from, litigation support. So you must familiarize yourself with this directorate if you want briefs, advocates. And then we've got the administration of military justice. Now, in the administration of military justice, obviously we've got military judicial services, we've got the prosecution services there, we've got the defense counsel services, judicial review, as well, lastly, as legal support in terms of court orderlies, court interpreters, and so forth. Now, lastly, we also look at force preparation, and this is the preparation or when we prepare MLPs to be able to support operations, the development of doctrine in terms of how are these military law practitioners supposed to support every level of war, but also combat readiness. And then also we've got, for example, training and development at the School of Military Justice, as well as Stellenbosch Military Academy. This is where military law practitioners also play a role. Now, I thought it would be interesting to just show some of the photos, and you would see as we go by. This is a photo one of a private defense counsel who is appearing together with our prosecutor in the picture. This is a Navy prosecutor wearing a nice ice cream suit there. Now, on the right, we've got an example of a military court, what we call a field court, with a judge presiding and the defense counsel in the picture. And the field courts are often, we set them up in operation. So there's no nice air-conned court councils for us where we are working. But also now on the next slide that you are seeing, slide 19, you've got the members of Defense Legal Services climbing the Drakensberg on an exercise. And you can see the snow is very thick. So when we are committed to a cause, it doesn't matter where or who we go, and we execute what we need to do, because ours is to ensure that soldiers at all levels are supported. And then we've got the picture of our Adjutant General together with our Admiral, junior grade, Admiral Kani, at a colloquium, US Africa colloquium. These are just some of the activities where we get involved in together. And hopefully, if Advocate Desta has anything to go by, we'll be joining another conference soon where South African Bar Association is involved. Now, let me then start from the beginning to give a brief picture that pre-94, up including 1998, we had the court-martial system that had been in place. And obviously, we know what happened in 94 with the new democratic South Africa being born. And then 96, we had a new constitution for the republic. But in terms of our history as military law practitioners or military courts, an important date is the 18th of December, 1998. This is where the Cape of Good Hope in Freedom of Expression Institute versus President Ordinary Court Martial declared the court martial system unconstitutional and placed a moratorium on all military trials because it had been declared unconstitutional. And then the matter was obviously referred to the Constitutional Court. But before the Constitutional Court could pronounce on this, on the 14th of April, 1999, the Military Discipline Supplementary Measures Act was assented to by President Mandela. And this piece of legislation is the legislation that creates military courts. So military courts are creatures of statute, and they are established by an act of parliament. I've got red markings there. Military courts are definitely not tribunals. They are courts of law vested with judicial authority. I would remind councils that Section 166 of our Constitution, A to E, provides for the judicial system of our country. But in subsection E, it deals with all other courts established by an act of parliament. Therefore, the MDSMA, being an act of parliament, implies that military courts are part of the judicial system of the Republic of South Africa. Therefore, they are vested with judicial authority, and the superior courts, I wanted to say, they are regarded actually by superior courts at the same level as all other specialized courts, your labor courts, your land claims court, your electoral court, your income tax court, amongst others. Now, what was the MDSMA trying to do? What was its purpose? And its purpose is composed in 3 issues. 1, to provide for proper administration of military justice and the maintenance of discipline. That's the first thing. The second one, to create military courts, but with a specific purpose. And that purpose is to maintain military discipline, but also to ensure fair military trials. But now, interestingly, it says the accused access to the High Court, or accused the right to access to the High Courts. Now, Section 6.1 of the MDSMA tells us the different courts that are created. The first one is the Court of Military Appeals. The second one is the Court of Military Judge. And the third one is the Court of Senior Military Judge. Now you've got another court to the left called the Officer Commanding Disciplinary Hearing. Now, this is not a court of law, does not meet the requirements. This is more or less your tribunals. It's not military law practitioners presiding there. It is actually line officers, people that are trained in law, but not law officers. Now, in the military, the first court, which is the Court of Military Appeals, is established as the highest military court. What this means is that its judgments therefore binds all other military courts, which are your 2 courts of first instance, being the Court of Military Judge and the Court of Senior Military Judge. Now, I would like to show this picture, and this is, for example, a virtual court. We were busy handling a matter where some of the witnesses were in China, for example, and I think the accused person was equally in China. So we also have these virtual courts in the military. Now, one thing is important is that we have to talk about the status of military courts. Now, the status of military courts is not expressly determined in the Constitution, nor in any legislation establishing military courts like the MDSMA. But what it says is that the accused person has a right to access the High Court of South Africa. So sort of indirectly saying that the military courts are lower courts or inferior courts, therefore equivalent in status to the status of a magistrate court. But which magistrate court? Is it the regional court? Is it the district court? Those are in some of the interesting questions that we have. But the judges of the High Court do not clearly determine exactly which of the magistrate court are these military courts akin to. Now, what is interesting today is that there are various functionaries in our military courts. For example, we've got military judges, we've got High Court judges and magistrates appearing in the CMA in terms of the act. Both can appear. But the practice has always been that the department would only call High Court judges, never a single day where a magistrate was appointed as a presiding officer. So it clearly tells you what custom is within the department. So High Court judges are chairpersons at the CMA. Then we've got military prosecutors. Private attorneys do appear in our military courts. Advocates, private, are allowed to appear in our military courts. And then Military Defense Council, they are there. Now let's look at the jurisdiction of these 3 courts that we are talking about. The first one is the Court of Military Judge. Now, first is jurisdiction over persons. It tries any person who is subject to the MDC or Military Discipline Code, and that only those that have a rank below that of major or its equivalent in the Air Force and the Navy and the South African Military Health Services. But also, it has jurisdiction over offenses. Now, the Court of Military Judge can try any offense except 3: murder, treason, rape, and culpable homicide committed within the Republic. They cannot try these at all. Sentencing jurisdiction. It may impose punishment as provided for in Section 12 of the MDSMA. Now, the punishments there are a lot of punishments, from imprisonment, for example. We've got cashiering, where you are stripped of your ranks in public, in front of your peers, where we have dismissal, for example. We have discharge of junior officers, amongst many others. But what is interesting is that the Court of Military Judge cannot impose an imprisonment more than 2 years. So they are limited to 2 years imprisonment. Now, the Court of Senior Military Judge equally has jurisdiction over persons who are subject to the code, but it can try any offense except murder, treason, rape, or culpable homicide. When these are committed in the Republic, the Court of Senior Military Judge does not have jurisdiction. But when these same offenses are committed outside the borders of the Republic, they have jurisdiction. So important there is extraterritorial jurisdiction in all instances wherever the soldier is deployed. But also sentencing jurisdiction, it equally can impose all the sentences that I have spoken to you about. And interestingly also, both Court of Military Judge and Court of Senior Military Judge have the power to impose post orders. We'll deal with that a bit later on. In terms of the jurisdiction of the CMA, again, obviously, everybody subject to the Act, and it can hear any matter handled by any of the courts of first instance, either on review or appeal. Now, the Court of Military Appeals also has authority to change any finding, sentence, or order handed down or made by any military court. Now, what's very interesting, for example, with military court, for example, is that it can, for example, make an order for maintenance or a maintenance order. It can make an order to recoup damages or loss to the state to the tune of whatever millions there are. They can even, for example, impose sentences up to like the Court of Military Appeals and the Court of Senior Military Judge. They can impose a sentence of almost unlimited in terms of imprisonment, for example. Now, there are various fields that inform our work, or fields that we deal with day to day. One is military law, that is what's commonly known, but we also have criminal law that we deal with, international law, medical legal or medical law, aviation law, cyber law, maritime law, and environmental law. But remember, there is many other fields that affect us: administrative law, and even labor, from a sense that within the defense force, there are civilians. So directorate litigation and advice would deal with some of those issues. Now, when it comes to review, the High Court, obviously, in exercise of its inherent jurisdiction, has the competence to review cases emanating from the Court of Military Appeals. But when it comes to appeal, one cannot appeal from the CMA to the High Court. You must appeal direct to the Supreme Court of Appeal. Therefore, the position is that the High Court does not have the competence or appeal competence over the CMA. I hope that is well understood. Now, again, I've always spoken about the fact that military law practitioners are equally involved in training the entire defense force on military legal issues or legal issues. That includes, for example, training on military law, training on the law of armed conflict, what civilians prefer, or some prefer to call, international humanitarian law. But also, as soldiers, leadership is one of the courses that's very close to our hearts, which we deal with. And then obviously we've got other programs that prepare the military law practitioner for being able to support operations. And that is the joint battle handling course. And then I think councils might be interested is that we also have the pupillage program within the School of Military Justice. Now, I thought I'd share a little bit about, especially I don't want to create an impression that we are taking bread and butter from councils. The aim of this pupillage program is to create a small litigation capability on behalf of the Department of Defense. I reiterate, a very small litigation capability on behalf of the Department of Defense. The second aim is basically to improve the quality of military law practitioners so that when DLA, for example, is working, Directorate Litigation and Advice, on a litigation matter with the state attorney, the quality of the brief now will definitely be much higher than previously. But also part of the pupillage program is that of corporate social responsibility for the department, specifically for those that come from currently disadvantaged backgrounds, not previously disadvantaged, currently disadvantaged backgrounds. Now let's look at the relationship then, advocates, between the Legal Practice Act and this military law practitioner. Now, the Legal Practice Act is silent on the question of whether a military law practitioner is or are legal practitioners. It is silent. It does not say anything about us. But one thing that's clear in practice is that many of our military law practitioners are either admitted as advocates and attorneys. But recently we have what we call a military discipline bill, which requires all military law practitioners to be admitted as legal practitioners. So when that act is passed into law, or that bill is passed into law, it will be then peremptory for all military law practitioners to be admitted as legal practitioners and for them to belong to the Legal Practice Council. Now, in terms of opportunities for you advocates, what are those opportunities? Now, whether it's attorneys or advocates, they can apply to be military judges within the military courts. That is allowed. For example, there are briefs in the Department of Defense, obviously through the state attorney, but councils can have briefs. But also, as a private defense counsel or as an attorney advocate, you can represent military clients in military courts. But also, there are opportunities for you as a bar association to receive, for example, training on military law, law of armed conflict and leadership from the department. It can be arranged. And then lastly, obviously, we've got the pupillage program, which provides an opportunity actually for the aspirant pupils, and then also the advocates at the bar can be facilitators and or mentors to our pupils. Those are some of the opportunities that are there. Having said that, I'd like to open then the room for discussions and debates. And then we are ready, and Major Raphuti is very fired up, actually. She wants to be asked questions. So I'm not sure if there are any, but we are ready to then respond to any of your questions. I submit, Council.
Thank you so much, Council, for that insightful session. One thing that rings true to our profession is that one truly never stops learning. This was incredibly awesome. And, you know, just sitting here listening and taking it all in took me back to my pupillage days when everything was just so exciting and so foreign at the same time. I am not sure if we have any questions, but let me quickly check the chat box. There is a question from Pule Moshwadi. Good afternoon, Advocate Moekoa. I have a question. Where does one access reading material on military law? That is question number 1 from Pule. And the second question from Pule is, how does one get to be trained in military law? So let me give you this opportunity to respond to Pule. Thank you.
Thank you, Pule. Pule, like the advocate has already presented with regards to the first question, although we don't have test books, but you can look into SAFLI, like he has already indicated that SAFLI, if you check on SAFLI, you'll be able to find cases there. But not only that, our Defense Act, if you Google our Defense Act, our MDC, they are available on internet facilities. The second question is in relation to where does one
Access, if they want to join military law course, for example.
What was the second question, Council?
The second question relates to training. Where does one train? Where does one get trained in military law?
It is unfortunate that, like he has already indicated, that in universities we do not have training in respect of military law. But however, once you are a member, this opportunity has not yet been opened to the public. Once you are a member in the Defence Force, we do have military law course in the Defence Force. Unless if you want to add on.
If I may clarify, Council, if, for example, the bar has an interest, or any bar has an interest to learn about military law, the Adjutant General has made it available to say the bars can write requesting the School of Military Justice to come and present. So if you would want to, you can write a request to the Office of the Adjutant General, and then we will be able to support that, because military law is the law of the Republic. It's not the law of the militaries. And the bar associations who appear and the attorneys who appear in military courts definitely have a vested interest to know about military law, but the Adjutant General would have to, through the proper channels, approve that, and that is possible. So Advocate Pule can certainly start writing a request in that fashion. Thank you very much.
Oh, that's fantastic. Thank you for that. Another question from an unknown user. Good afternoon. How can I apply as I am currently a third-year LLB student?
Well, all of the posts for military law practitioners are openly advertised on the DPSA website, where all government vacancies are available. There's currently no post at the moment, but in the event that they become available, they will be made available on the DPSA website, and then one can follow the DPSA for guidance.
But that doesn't limit you from still making application to our HR division that is situated at Defense Headquarters in Amsco Building. You can just check the website there, Google DOD. It will appear there. Defense Headquarters at Amsco Building, there will be a website there. You can still make your application there for in case once the applications are made available.
Thank you, Carl. I sure hope you got that a response. Another question coming through from Lebohang. Lebohang asks if there is any mentorship offered for LLB students and how to apply if that is the case.
Council, I must emphasize, if it's mentorship, for example, for one to either be an attorney or an advocate, we don't have that capacity at the moment. We ourselves depend on the generosity of bar associations. Currently, the Pan-African Bar Association and the Tshwane Society of Advocates. So we do not have, as military law practitioners, that capacity yet.
All right.
But as we obviously get more and more military law practitioners admitted as advocates, and they are in full-time practice, then maybe the future is bright. Carmen must, is it Lebogang, must call us in maybe 2-3 years. Who knows?
Who knows? Indeed. There's another question coming through from Dalantu N. He wants to know, how do private defense attorneys approach military personnel in order to assist in their defense in military courts? So this relates to private defense attorneys.
I would advise, we have like the advocate has already indicated that we in the military administration of justice system, we have the defense council, military defense council. There's also a senior military defense council whom you can also approach in that regard to get assistance, especially when it comes to certain rules regarding accused person. But we are all open as military law practitioner like myself. I always get a private attorneys who will then come and ask, how does this procedure work, or how does this rule work? We are all open to assisting in that regard. But for the sake of yes, to avoid a conflict of interest or stuff like that, I would then advise them to approach defense councils in the military.
I think also the other thing is that as attorneys and so forth, we have to think out of the box in terms of, obviously soldiers are part of the community, and if you make yourself your practice prominent on social media profiles, proper advertising in and around areas, people will start to get to know you, all right? And that's the one way you do it. I've seen in some units, for example, businesses would come and request an opportunity to present their services. That's perhaps one of the issues where one can go to the command group and request an opportunity to share their services with members. So there are many other issues. One can approach, for example, some of the unions that represent members to say, I want to be on your panel of attorneys and so forth. So there are ample ways one can do that. But otherwise, they are free soldiers to choose whom and where to get services, isn't it? So I do not have the answer meaningfully, but those are some of the hints that one can follow to get clients, military clients.
Absolutely. Thank you for that. A question from Amina. Amina would like to know the procedure to change corporate to legal divisions, as I am already in the Defense Force and currently in my 4th year in LLB, and I'm 25 years old. So
to change core, Amina must just follow the channels of command, right? Write the letter from where she is through the chain to Legal Services Division. And as and when opportunities arise, Amina can definitely access those opportunities. But the other one is that one can try also to request a detached duty to legal services so that in the meanwhile you get exposure to the legal field. So, but it must all work through the chain of command because Amina is already a member of the South African National Defence Force.
All righty. Another question coming through from Mobile. She wants to know the process in becoming a judge in a military court.
Now, there are various ways. One is that you must have served as a military law practitioner for many years with adequate experience. And if the command group, the adjutant general deems you fit and proper person to serve on the bench, he could make recommendations to the Minister of Defense for your appointment as a military judge. But let's say you are an experienced advocate and attorney who've been working and you are outside and you have an interest to serve as a military judge. All you do is you write direct to the adjutant general and indicating who you are, your experience, your interest, and attach obviously the CV so that he can then have an opportunity to talk to you and check what is possible, because we cannot obviously have space for everyone that wants to. but it is definitely possible.
And they will call you up as a reserve force member.
Yeah, that one is very important as well, Advocate. You will not necessarily be a permanent force member of the South African National Defence Force. You will be, for example, a part-time member. For example, let me give an example of judges. There is, for example, Judge President Mlambo of the Gauteng High Court. He is a military court judge. Judge President Lekhodi, military court judge. Justice Muchumi, military court judge. Judge Bam is military court judge. There are so many of them that are already on the list. And any of you that have an interest can make that available, and it's easy.
Oh, stunning. All right, thank you. I think there's another question that just came through from Masaya. Please could you share the HR address at which applications to join the military may be made?
Wow, the general military, if one wants to join, applications are sent out every second year now, around February. The 1st of February, applications will be open, and then they will end on the 29th of February. Because that is not a legal side, I do not have at this moment an answer, but there is a recruitment office, I think near Fisahi Street. There's a recruitment office near Fisahi Street where one can definitely join. But in terms of the address for legal services, you can go to the AMSCO building, which is based near, is it Conan Nosop and what is Conan Nosop, and I forgot the address. I'll make it available to you, Council, and you could probably hopefully share with them. But I'll also try on some of my platforms, share that information in terms of the actual physical address, but it's near Erasmus Kloof there.
Would highly appreciate that. If I'm not mistaken, I think it's off the Dalmas off-ramp from...
Yes, Dalmas and Kona Nosop. But if they just Google AMSCO building, they will be able to find it exactly.
The exact location.
And
All
when
right.
they get to the security, they must just indicate they come into legal services. That is block 2, level 2. And then they must just indicate they're looking for HR people, and they will be assisted.
All right, thank you. Another question. What is the most concerning matter you are facing as military practitioners at the moment? This is from an unknown user.
I don't know if I should be worried to answer this question.
Posing, yeah.
Well, I must say I've had a very fruitful experience as a military law practitioner. My challenges are very simple. As a military law practitioner, I need to be recognized by the Legal Practice Councils. The regulations of the LPA, Department of Justice, and the broader legal profession must definitely come to the ball and change that. The reason is simple. If we say we are in a military court, and that is a court of law, part of the judicial system of the country, the rights or the protections that are afforded to any other attorney, advocate that appear in that military court must equally be afforded to me as a military law practitioner. Currently, the status is simple. Some military law practitioners who are not admitted as advocates and attorneys, their status is problematic because they're not recognized as anything. So when they have to leave the department, they must go and start from scratch, even after 20 years experience. But if military court is like any other court, part of the judicial system, then we must be recognized by the profession. I wonder if the LPC even knows that we are a military court. And if there are defense counsel representing clients, I wonder if the same protections should not be extended by the LPC to military clients. Because if, for example, I go to a civilian court and I have a problem with the attorney there, I can report that attorney to the LPC. But if I'm a military client and I have a problem with the military defense counsel, suddenly I can't do what? I cannot report that person to the LPC. Even if I do, the LPC will say this person is not my member. So there is no equality in terms of protections afforded to clients, but equally afforded to me as a military law practitioner. Like, for example, Council, this is the last one, I promise you. If you go read the regulations of the LPA, you will find that the experience of a prosecutor in a civilian court is recognized, but ours is not recognized. So if, let's say I was an attorney and I want to apply for a right of appearance, I cannot rely on the experience obtained as a prosecutor in a military court. But miraculously, I can apply or use that experience that I obtained as a prosecutor in a magistrate court to count for my right of appearance in the High Court. So those are, for me, the bailing issues.
Has there been any steps taken to address these in the past years?
In the past years, for example, I must emphasize this, Council. When the judiciary transformed, they left the military judicial authority. When the legal profession transformed, they left the military prosecutors and defense counsels. What that means is that the legal profession can, for example, recognize members of the South African Human Rights Commission, but they can't recognize military law practitioners. They can recognize people at legal aid. They can't recognize us. So those are the burning challenges as far as military law practitioners are concerned. Yes, the department is busy. Progressive realization of rights, and Gary Council. We have started first to say, let's train people, hence the pupillage program. That's the first phase. And the second phase, obviously, will be to approach the LPC as far as those are concerned. The instructions were out, but we were told just to finish step by step. We build step by step, but it's good to educate the legal profession about these challenges so that they can start to understand, because it's the same LLB that we study, isn't it?
I think we have also studied in this way, Council. This presentation in itself, we have also started to educate people about the military law practitioners.
Absolutely. We have 2 or 3 more questions to go. There's a controversial question by Nompumelelo. She wants to know, or he wants to know, I'm sorry, I'm not sure. Can you please touch on the salaries when you start as an admitted legal practitioner in defense?
Council, I can tell you, no, I will tell you. She will be very happy, very happy. The salaries are enough, more than enough.
We are still OSD compliant. Based on your experience, that's how you get paid. It has nothing to do with your rank, but with your years of experience. The same as outside.
It's very competitive, Council.
I'm sure
you
you
must
have.
not worry.
Another question from Kamokhetwe. Is the South African Defence Force open to working with voluntary legal organizations and spreading the knowledge of military law? And if that is the case, what are the channels one should follow to connect with them?
I would think the Adjutant General, if such an offer would come, would be highly excited. But the channels always, with such issues, particularly voluntary legal organizations, we need to get through the chain. The chief of the South African National Defence Force, they must write there, then legal services will get instructions, and then it should be possible. But I see no reason why there should be a hindrance. But also one I would think could easily also approach the Ministry of Defence broadly to make it a national imperative, you see, at that level. Because if the minister is of the view that private defense counsels must come to our courts, they definitely have to understand, isn't it? Therefore, education becomes very important. So if there is such opportunities, I think they can really do so.
I agree. Another question from Kezo Lutle. Is it necessary to serve articles before you can be admitted as a military attorney?
It is not necessary. However, I would say it is advantageous if you are admitted, because it sets you apart, isn't it? But also your salary will also be up a notch, you see. So there are many other benefits of being admitted before you can. And the other thing is the new bill, the military discipline bill, makes it compulsory for one to be a military law practitioner, they must be admitted. You see, but it has not yet been passed into law. But maybe we wake up next week, who knows? We don't know when the president will sign.
Absolutely. CM Tanda wants to know, how can you exactly, or rather clarify, how one can become a military attorney, please?
Well,
so LLB, I guess we'll take it from obtaining your LLB.
Now I have my LLB degree.
Yeah.
Now the South African National Defence Force says we want soldiers. Remember, military law practitioners are soldiers, nothing else. They are soldiers who happen to specialize in an area of law. We've got doctors, we've got nurses, we've got almost a lot of skilled professionals inside. So you would apply to join the MSDS program, military skills program, and then you'll be absorbed as a soldier. You'll do your basic military training, where you are now introduced to soldiering. And then whilst inside now, they will then say, no, this one, because this one has this degree, your corner will be your MLP. You'll come to Legal Services Division. Others will go to infantry, others armor, and other issues.
Clear enough. Okay, another question. Are you able to estimate the number of military practitioners that we have?
We have a lot. We are actually close to the whole capacity of the state attorney office.
Oh my. Okay, that's a considerable.
That's how big.
Yeah.
The state attorney currently speak about 220 something. We are very close. I won't disclose our number, but we are very close. But it should give you a picture.
Yeah, no, that's a considerable number for sure. Advocate Romeo wants to know, how long is the duration training for advocates who are interested in military law?
Military law is about 1 month course, six weeks, all in all. Okay. But obviously for councils, for them to get orientation, because a lot of the curricula is already what advocates and councils have, but there will just be specific issues that could be specific to councils. So they would not do the whole curriculum, but only those, like for example, within military law, you'll do law of evidence, criminal law, and all of those things. But for advocates, that won't be necessary. But the rules, for example, in military courts and some other aspects would be necessary. So their curriculum, if such a request is there from, let's say, South African Bar, they would not do everything. It would be tailor-made to suit their status or their level.
Understandable. All right, I think this is our last question. Are you able to please explain further regarding appeals and reviews from CMJ to the High Court? This is from Unknown.
Okay, let me explain it this way. The High Court, it starts with the status of the Court of Military Appeals. It is not clear what is our status. Are we a magistrate level? Are we a High Court level? That answer is not there in the Act, except to say access to the High Court. The accused has a right to access. Now, that being the case, the High Court has inherent jurisdiction. So, having inherent jurisdiction, it has then the review competence over all CMA matters. There is a number of cases that deal with this. For example, one can go look at from Moekoa matter, the Minister of Defense versus Lieutenant Colonel O'Brien, amongst others, and it will speak to this. Then there are others in terms of appeal now. High Court does not have appeal competence over the Court of Military Appeals. This is because the Court of Military Appeals is deemed to be the appropriate court that can impose a just sentence on military-related aspects. So if one is crying about the results of the Court of Military Appeals, they can go straight to the Supreme Court of Appeal.
In simpler terms, what my colleague is saying is that once an accused person has been sentenced in a court of military judge or senior court of military judge, the accused person has a right to appeal at the Court of Military Appeals. However, the High Court, how it comes in, when it's issues of review, then he can go to the review, to the High Court for review. He cannot appeal the judgment of the CMA at the High Court.
Correct.
Clear enough. Lastly, well, we've actually gone over time by 5 minutes. Saya wants to know, may you please advise how one applies to join the panel of attorneys for the military?
That one is, we work through the state attorneys. You see, we don't have a panel of attorneys in the Department of Defense. So the briefs that involve our matters or matters of the department, the state attorney offices handle those. So one can definitely approach the state attorney to get more clarity on those issues. But remember, they also issue briefs based on the competence and the specialization of counsels. So if you don't have any military experience or national strategic training of sorts, you will not be approached easily to handle national strategic matters or our matters or matters from the Department of Defense.
Got it. I think any further questions beyond this, I imagine that our participants can also just look back at the recording, which we will put up on the Saba with YouTube channel, because I can see that there's some questions that have already been answered. Sandile wants to know, what can one do, or rather, where can one do their military training and what are the requirements? If you can just touch on that in 1 or 2 lines, but I know it's somewhat has already been answered. If you can just give him a brief answer to that before we close.
Now, each of the services, as I've indicated before, would do recruitment drives. And those requirements differ from service to service for one to join the military. So once you are successfully recruited, then now, depending on whether you apply to the Air Force, the Navy, South African Military Health Services, you will be sent there. Now, when you are there, the different requirements differ, right? So I don't have those properly at my disposal now because it is outside the embed, but I will share it on my Facebook page a little bit later on so that whoever wants to can access them.
All right. I want to take this opportunity to thank you both for availing yourself, for giving us this insightful session. It was truly, truly an honor to be a part of this. Lastly, are you able to make the presentation available to us so we can utilize in future?
That shouldn't be a problem, Council, because it's most open source issues that we are dealing with.
Yes.
You can even read them for yourself in those sources. I will share maybe with you also all of those instruments, the sources that I spoke to. If you can send me an email address, I'd gladly share, and you can distribute among your members because they are public documents.
Thank you. And lastly, your Facebook account that you mentioned, because I'm sure it's probably going to be flooded this evening. Do you mind sharing your Facebook account with our participants so they can engage with you directly if need be?
Council, they can go to what we call SA Law Hub. They will find a lot of content relevant to this. They can find Advocate Moekoa Speaks on YouTube. There's a lot of videos that I download relating to the same. They can go on Advocate Moekoa Facebook page. They will also find the same. They'll find me on LinkedIn as well. So those are just some of the platforms.
All right. Thank you. Thank you so much. And thank you to our participants for being a part of this session today, and to our speakers. Have a good afternoon and all the best in your fight as our soldiers, as you refer to yourselves.
You must support us, Council.
Thank you.
With 101. Now we know.
Thank you very much,
Thank
ma'am. Much
you.
appreciated. Bye-bye.
All right. Cheers.
Bye.